Right, I'm going to ask everyone to please find a seat. We want to stay on time. Hi, my name is Callie Dietz, and I'm with the National Center for State Courts and very pleased to be working with NACM as their conference education planner. And I'm going to be hosting this session and helping out a little bit as we go along. I wanted to introduce your panelists to you very briefly and ask you to participate. This is going to be a fabulous session. Just to remind you, if you didn't already know, this is going to be one of those very innovative sessions about how courts can really engage with their community and learn from secret shopper experience. And that's all I'm going to say. That's just a prelude to what you're going to hear. This is a project that I'm a little bit aware of because I've just retired as a state court administrator in Washington State, and this is going on in Thurston County District Court, which for those of you who are not aware is Olympia, Washington, and these folks have done a fabulous job with it, and I can't wait for you to hear what they're going to do. So let me first introduce to you Brett Buckley. Judge Buckley is the presiding judge of the Thurston County District Court. He's also the judge that presides over the mental health and veterans courts. He is extremely knowledgeable. I could go on and on and on about the different committees he's involved with and all of the work he did. I can attest to you personally that he is very active, very involved, and one of our most innovative strategic judges. If you want somebody that wants to know what's going on in your community and how to do a better job, you could not find a better model judge than Brett Buckley. Also with us this morning or this afternoon, I guess, is Robyn Mazur, who is Director of Gender and Justice Initiatives for the Center for Court Innovation in New York City. She provides strategic planning, technical assistance to courts and communities that are very interested in trying to expand their outreach and their work for women and children in this area. There are bios on the app if you'd like to go and learn more about them. One person who is missing, and I just have to take just a second to mention her, is Jennifer Creighton. Jennifer is the district court administrator for Thurston County. She used to be my AOC employee and is just wonderful. She would be here, but she's under 15 inches of snow back in Washington and was unable to get here, so I'm going to try to pitch hit a little bit at the end and fill in her part, so forgive me if I don't do well. I'm also going to try to host this session, and I only bring that to your attention because as we ask for questions, or if you raise your hand for a question, give me just a second to get to you for the mic, because we will be recording and live streaming this session, okay? I want to remind you now, and I will at the end too, we hope you will take a few minutes to go to the app at the end of the session and evaluate it for us, because we really do value your input and your feedback on the session. So I'm going to turn it over to Robyn, who will lead us off, and we'll get started. Thank you.
Hi everyone, welcome, and thank you for coming to our session. Thank you, Callie, for the introduction. So we're going to cross our fingers that this slide machine the PowerPoint is working. Because it's there, yay. So we're going to start this afternoon with really giving sort of a grounding and a framework around procedural fairness, or also known as procedural justice. How many people in the room have learned about procedural fairness before? Oh, great. And people at your computer, hopefully you're raising your hand too. So we have a fairly knowledgeable group here. And then Judge Buckley is going to talk specifically about how we took some of the framework and they created really a secret shopper concept. And myself and some colleagues went to Olympia as the secret shoppers and gave some feedback. And then Callie's going to pinch hit for Jennifer to tell you a little bit about the outcomes and the resources from that. So, the definition of procedural fairness. The key word in this definition is perception. It's the perception that you're treated with respect and taken seriously by an unbiased, oh my gosh, and I'm telling you, it's a little wonky, so you have to just give me like a look when you're like, wait, what are you doing? When your concerns are taken seriously by an unbiased decision maker. But really, the word perception is really, really key here. So what I love about training on procedural fairness is that it's a concept that's really common sense based. And for those of you that have worked on this before, you know what I'm talking about. But it's grounded in research. And really what's so interesting about it is that while the concepts are very commonsensical, if that's a word, but I think it is, it really shows that if these principles are adhered to, that basically there's more compliance with orders, and the process is perceived as fair. So when we're talking about procedural fairness, we're pretty much talking about 4 key principles. Some people say there's a 5th, which is a little bit controversial. I'll tell you what the 5th one is. I don't think it's really controversial, but people do talk about a 5th principle. But they are voice, neutrality, respect, engagement on a human level, which a lot of people also use the term understanding. And then the one that is sort of that 5th element is helpfulness. And it's really, I love this quote here that says that the public will not entrust its confidence to a system of justice it cannot navigate, afford, or understand. And I think that's really key in terms of what we're talking about today. And it's really, these concepts are, people still like to win, whatever win means, right? And these principles are both for plaintiffs and or defendants and respondents. But if they feel that the process was fair, the decision acceptance will be higher, meaning that they'll still feel that the process was fair and therefore they will comply with the orders. And this has been studied for since the 90s by Tom Tyler and then other researchers through today. It was primarily studied most in the criminal justice sectors, really even with law enforcement, courts, corrections, but over the years it's also been studied more in the civil side and the family law side. So here's more of the research, and I like this slide because really what we're also talking about are the immediate effects of procedural fairness. So this concept that the fairness is more influential than what people call the distributive justice, or the winning or the losing. And one of the examples that I give on research on this one is actually from Minnesota in the family courts there with orders of protection. There was a randomized trial where half of the group in an order of protection docket, the judge just gave, whether the order was granted or not. There was not an explanation as to why that decision was made. And then for the other half of the group, granted, not granted, but then a full explanation of why that decision happened. And they talked to the litigants after their cases were called, and the litigants who had the full explanation, and this is probably not shocking to anybody in the room, but guess who thought it was more fair? The people who had the full explanation of what happened, and they were more likely to comply. So I think that's very telling. And then the enduring effects of procedural fairness about increasing compliance and recidivism. And there's been a lot of research, like I said, primarily in the criminal justice field, but looking at all the way from arrest all the way through the court system. If people felt like the system was fair, then they would obviously comply, but there was research that showed if people didn't think it was fair, they then didn't think the court was legitimate, and then they were more likely to have another criminal offense. And I think it's really interesting to kind of put this in the frame of, across the country for the past couple of decades, our crime rates have overall been dropping, but yet, this part should make us a little sad. The confidence in our systems have not necessarily been going in that direction. Our confidence has dropped instead of going up. And I like to think about this because when you're going to hear Judge Buckley talk about the project that we did with Jennifer and the judge and their team, it's really a teachable moment. When we went in and looked through and used this framework of procedural justice principles, we started in the parking lot looking for this, right? All the way through the court observation piece. And so when we're thinking about how to build legitimacy, public trust, how we're going to improve our courts and litigants' perception of fairness and compliance with those orders, it's really each of those moments that they're all those teachable moments. So this is my favorite. So I train on this a lot. We train in communities with judges and with court staff and with stakeholders. Because like I said, I really think this concept, I'm hopefully that you're getting the picture, is not just about judges and court staff, right? This applies to attorneys, this applies to probation, this applies to the whole world. But I also love it because it's not just about our work. How many of you have had an incident? I like to use the DMV, but some of the places that I train, they tell me their DMVs are fabulous, so I don't know. I don't live in a place like that, but I had a recent experience dealing with my cable company, trying to reduce my monthly bill on my cable, and it was so frustrating. I was on hold for seriously like an hour at work. Luckily, I had speaker hands-free, so I could do my job. But anybody else ever frustrated outside of their work? Airports, the judge just had a crazy time getting here. TSA, urgent care. I mean, probably the list goes on and on for people. So this is not just a court problem. As you can imagine. And my experience in all of those areas, how did you wish that you had been treated? That somebody at the DMV, instead of waiting 45 minutes to get to the front of the line, that they tell me, oh, you can't pay with a debit card, you really needed cash. Okay, fine, now I just was there, I filled out my form, I waited, now I have to go back, I'm late for work. I wish someone had posted a sign, had told me when I walked in. So basically, treated with respect and an explanation of the process and what to expect. And like I said, we can all think about that in our quote unquote regular lives, but it absolutely holds true with people using our systems. I love this also because making a decision is a sign of authority and explaining a decision is a sign of respect. And so once again, really thinking about all of these principles and thinking about how we can do a better job, making sure that the litigants in our courthouses understand what's happening. It's a really confusing time for them when they're accessing our systems. So here's what we've been talking about. And when we went in and we're talking with the judge and Jennifer and their team, this is a big undertaking, and you're going to hear about all of the steps that they went through, but many, many ways of changing and improving your system to make it more procedurally fair, procedurally just, are actually, some of them, not all, you'll hear more of them from the judge, but some of them are actually very inexpensive, are ways that you can just kind of change the way that you're doing business, basically, and can be implemented fairly easily. We know that, for example, voice is a way that somebody can be heard. We know dockets are crowded. We know the resources in the courthouses are often stretched. But we know so many litigants, particularly obviously in our civil sides of the world, there are very few people that are represented by attorneys. Most of the time, people are coming in by themselves and they don't understand, and having an opportunity to speak and to ask questions is important. Neutrality. And obviously, as courts, we always think of ourselves, no, we are neutral, we're impartial. But I always give the example of a situation when we were doing some work in a jurisdiction. We were doing some court observation, and then we did some interviews with litigants after. And it was so interesting. The court that we were working with was a specialized court, so the judge and the attorneys and everybody in the court, that was their day-to-day. They were all dedicated to that particular courtroom. So they're all friends, right? They're opposite, one's prosecutor, defense, but whatever, they work together, they're coworkers. So it was a Monday, they had come in from the weekend. It was before the cases were being called. There were litigants sitting in the audience section of the court, and the folks were just chatting, about the weekend, and they start to laugh about something, nothing related to the cases at hand, completely unrelated to the cases that were going to be called. Later, when we did some of the interviews with the litigants, their perception of what happened in court when they were waiting for the cases to be called was that those attorneys and those people working in the court were talking about the cases and laughing about them. Now, that was not true, right? That was not really what happened. But the perception that it was sort of rigged and that, these people were talking about them was really, really powerful. So also keeping in mind all of those components of procedural fairness and how to conduct ourselves. Obviously, respect, treating people with dignity, eye contact, trauma-informed, using the person's name, proper pronouns, and the engagement on a human level or understanding. The obvious one is language access. Hopefully everybody's doing a lot of work around that with interpreters, but we also spend a huge amount of time talking in the courts about plain English or making sure that all of your forms, not in legalese. I say 5th grade. I've been challenged to people have been saying, oh, you have to do 3rd grade. I don't know, it's really hard to get your forms down to 5th grade level. I don't know if anybody in the room has tried to do that. But these are all things that are really important when we're thinking about how to make our systems more procedurally just. And for example, what gets in the way? Well, there's lots. I think all of us, we can hopefully raise our hand, we all think that we strive to do this every day, right? Nobody sets out, I don't think, most people do not set out to not meet all of those areas, but we're busy, right? And things get rushed, and there's a lot of reasons why we sometimes are not meeting those marks. Some of them are even just, our forms. Well, that's the way we've always had. Our forms have been like that for 20 years. Nobody has time to go back and take out the Latin or take out the legalese. Well, actually, it might help your litigants and actually help people get through your process faster, right? But this is, who knows? I went to law school, but I don't talk like that. And so, I think that people, thinking about ways that we can do that. I have to make a plug. Tomorrow, I think in the morning, my colleague Emily Lagrada is going to be presenting with some folks from New York about a new signage and communications project that they've had there. But I want to preview this because signage was actually part of what we talked about with the Olympia judges and court staff. And this is another, what we call kind of the low-hanging fruit, kind of ways that you can improve. This is from my lovely jurisdiction of New York. This is not very procedurally fair or just, it's very rude. I think it's rude. And this picture here, it's complete jumble, right? It's hard to read. It doesn't really make sense. You can tell it's some names, but it doesn't really give you a lot of information. But here's some nice signage, also from New York. So, we try to do both ways here. But using visuals with pictures, right? Understanding that there's different literacy levels. The term please and thank you, questions, more colorful kinds of information. So these are things that, courts can do fairly easily. And then also getting back to our neutrality and our fairness piece. These are also signs from my lovely hometown, right? And there may be some real reasons, if you're a judge, right, why you may be calling certain cases first, for example. So for example, you may need to, an attorney may need to leave that courtroom to run to another courtroom or to another courthouse to do another case. Or the judge knows that that attorney is charging that litigant for every minute that they're sitting there, right? Or the jail cases need to go first because there's transportation issues. So there may be real legitimate reasons that things are being called in the way that they are. However, the person sitting in the back, the other litigant sitting in the back of the courtroom may think, wow, well, if you have more money and can pay for a private lawyer, then you get to go first. So the rich people get to go first and I don't get to. That's not the perception that we want people to have of our court systems. That certainly completely undermines the legitimacy and fairness of it. So if a judge on the bench says, good afternoon, everyone. We're going to be calling these cases today with the attorneys first because I know these XYZ attorneys need to be in the other building for their cases. Then we're going to go to this case type because of X, and then and everyone here is going to have their day in court and be able to have their case heard. That would make somebody sitting in the back feel like, okay, now I understand there's a system here and we're being transparent. So I think those are kinds of issues that we work with courts on too. So there's some good stuff happening, not only in Olympia that you're going to hear about, but all across the country and the world you're going to see in a second. But I love this sign from Arizona, and I like it for a lot of reasons. I think it's written in fairly plain language, but it's also really positive. It says what they can do, right? So when litigants come to a clerk's office or to get their paperwork or to do intake, they're often really overwhelmed, right? And they don't know where to go, they don't know what to do. And this says, here's the things that we can do for you. We can explain and answer general questions about the court process and how it works. We can provide you a court schedule. We can give you court forms and instructions, right? And then it obviously gets into the stuff that they can't do, right? We can't give legal advice. I can't tell you what to say in court. I can't tell you what the judge is going to do. And that, sets it out there for people so they know what to expect. And so this is one of my favorite examples to use, because I really think it also makes people know that we're treating everyone consistently. It's not like, oh, I like Callie's case. Callie seems nice, so I'm going to give her more information, and Judge Buckley doesn't seem so nice, so I'm not going to tell him anything, right? This kind of sets out, we're doing this for everybody. And as I said, this is really kind of information that's being used across the world and in different kinds of professional roles. So this is an example in Australia where they started to use, the police officers there were using scripts in their, this is like, breathalyzer, DUI kind of checkpoints. And they say things like, we appreciate your time. And I have to say that we've been working in some of our workshops with judges and judicial officers, but sometimes with court staff too, on writing scripts, right? Because we get rushed and we get, we got 100 cases on the docket and we got to move on this. But we've really worked with people to say, good morning. You'd think the judges are really, it's hilarious on this. We'll say work on these scripts, and they do a really bang-up job on they write in plain English and they write all the things that are going to happen, but they forget to say good morning and things like that. So we always joke about it. And then also components around if you're running late, things happen, right? Somebody's late, or if the line is very long in the clerk's office. I'm sorry, we're running late today. Or we're short-staffed today. But that goes a long way in terms of working with folks. I have one more slide, and then you can, and look, I was thinking, can we do these? We're going to talk about Slovenia. Who knew that we'll talk about Slovenia? But they've also been doing work in prisons, implementing fair and respectful treatment and showing that it's promoting more compliance. Ooh, once again, it's being wonky. Sorry, everybody. And so across the board, we're really trying, countries across the globe, our own places here in Olympia that you're about to hear about, have been doing a really great job in trying to improve fairness and procedural fairness in our communities. So thank you, and I'm going to turn it over to Judge Buckley. I don't know, do you want to take a question and then we'll move on? Okay. I just didn't know.
Just a quick question. When I entered the workforce as a police officer and went into the courts, I learned from individuals that I was a young officer and worked for people twice my age, and they were very good at communicating with the community, spending time in the community. And I noticed an evolution over the past 30 years. I don't know what to attribute it to. I thought maybe it was because those in my age group, we played in the streets and we had to interact with each other. But maybe that the younger folks nowadays interact more over video games and text. I don't know. But are you finding that, are you finding that the generations that succeed my generation, our generation, that we have to focus more on this? Are we seeing, in terms of verbal skills and how to interact with the public, I do see times where I think I see public officials being short with individuals, and I don't think they mean to, but I just think it's part of a changing culture in the generations that succeed us. And I'm just curious, is there any formal recognition of that and training programs that are focused on that issue?
That's a great question. I don't know that it's completely attributed to age. I mean, I think, as you describe, I think what's happened And maybe it was always there, but it feels more acute, maybe at this point in our court system being taxed and also tons of people being self-represented in lots of different ways, is that we're busy. I perceive when I go to communities and we have these kind of workshops, people say, you know, I mean to do that. You know, I do mean to come out and say good morning and I'm sorry we were running late. And people in the clerk's office do want to help people as much as they can, but there's a line, you know, out the door and around, and people feel stressed. So I mean, it's an interesting concept. You know, we talk so much to people online now, so maybe our skills of direct interaction are diminishing, but my sense of talking to people around the country is much more people feel really taxed in the resource area. But I don't know if other people have thoughts on that. I don't know if Judge or anybody, but that's what I've seen. Anyone else? All right, well, I'm gonna turn it over to the judge, and we're gonna load up a video. So let's all cross our fingers.
We won't start with the video, so I'm going to start this way.
Okay.
It was a dark and stormy night.
Oh, all right.
2 years ago, in fact, when I hit the road on Interstate 5 heading south from Olympia to Portland, Oregon, which was hosting the Midwinter NACM conference, and it was a blizzard that I was driving through. I-5 was reduced to one lane for about 60 miles. And that has nothing to do with the talk today, except the fact that my trip here was even worse. And it's like, seriously, NACM, let's find a place where it might even be sunny. Okay, I got that out of my system. So I show up in Portland, and the conference is essentially regarding this issue of procedural justice, procedural fairness, and that's what attracted me and my court administrator to head down there. And the first session, the plenary session, was put on, I want to make sure I get the names right. And by the way, the context of this and timing is that it was, you know, fairly shortly after the riots in Ferguson, and us becoming aware on a much more general scale of issues of procedural justice and procedural fairness and the lack thereof. So the panel that I was listening to that day was Reverend Andrea Alexander. She's an attorney, and she works for the National Council of Churches. Judge Jimmy Edwards from St. Louis, and Judge Ronald Adrian from Cleveland Municipal Court. And all three of them are black, and they're putting on a panel discussing the facts related to the theory that Robyn was just putting out. You know, she gives you the academic information behind it. And they were talking about, let's take it one step further, how that looks to the justice system when you're sitting and you have a specific role in the justice system. What does that mean for those of us? And you know, they went through a lot of the same things that Robyn was just talking about and putting them into real terms. And it was a big packed room, and we're all listening, and I'm sitting there with Jennifer Creighton, my court administrator, and we're taking this all in. And you know, they basically challenged us, and they said, you know, looking at all these different things, and to the question that was just raised, is this a generational thing? Is there just something going on there? And they said, you know, it's important that we recognize that we have this gap sometimes with some parts of our communities, and maybe large parts of our communities. It's a gap in communication. That is, sometimes we're using words that other people don't understand, and sometimes they're using words we don't understand. It's a gap in engagement. Does the court look entirely different than the people who are appearing in front of it? We need to be aware of that. And then, you know, you put those two gaps together and some other gaps that Robyn was talking about, and we get a credibility gap. And it's been long a philosophy of mine. I've been on the bench for about 26 years now. And one of the things I think is the number one thing in my judicial philosophy is that there has to be a connection between the person appearing in front of me, criminal or civil, and their belief that I can be fair and that I've heard them. That is absolutely essential, because otherwise what I'm doing is wasting time, because whatever result I give will just be ignored because there's no faith in what I've done. So that's always driven my view of this process. And I listened to these folks talk about this, and I was aware of what had happened in Ferguson, and now these judges in non-emotional terms are indicating to me this is real. It's not just a spark, it's not just something that happened. It's fundamental and it's systemic, and we need to be aware of it and we need to think about it. And so that was the mode in which I was listening to them speak. So if we can play the video.
Okay, let's cross our fingers, I think.
And if we can't, then I'll describe the video to you. I won't act it out, but I'll describe it.
All right, here we go. Do we need the sound up?
It's not appearing on the screen.
Oh, it's not? Oh, it's appearing here. I don't know why. Do I have to drag it over? To...
See, when this happens, you develop this huge expectation for what you're not able to see.
Look.
Okay.
Oh. Well, this is an age problem because, and I'm not telling you how old I am, but you might want to guess.
And you've noticed I've asked Robyn to run the technology.
But I can't find the mouse all of a sudden.
And neither of them asked me.
Wait, where's my little, okay.
There you go.
All right, I got it. Oh gosh, oh my God, I'm a disaster. Okay, here, let's do that. And then let's go here. I'm now on mute? No. Oh. Where's our sound? Hold on. Where's my sound? This is not my computer. Oh, maybe.
Okay.
No.
Hey, Robyn, why don't I just explain it?
Okay, I'm gonna go drag it back.
Okay, so let's just start off with the image. I'll tell you, I'm the one who picked the video, so I feel obligated to at least give you some hint as to why I put it on there. So it's an excellent video. It's put together by the California State Patrol, I believe, and it's a white police officer and a relatively young black driver. And the opening scene actually was him with his hoodie on, and then he's driving a car, and then the next scene you see is they're sitting in that coffee shop at a table. And what they have actually done is they've jumped ahead in time, and they're each having conversations that they want to have with the other one, but they think they probably aren't going to have in the context of what's about to happen. And so you have this police officer saying, I pulled you over, this is why I pulled you over, and this is, that's the only reason I pulled you over. And then you have the driver saying, I get scared and nervous every time I'm pulled over by a law enforcement officer. And I don't think I was doing anything wrong today, but even if I was, I don't think I'm going to be treated well in the context of what is about to happen. And the officer's saying, but you don't know me. I'm a good guy. I don't do that. And I'm just going to do what my job is, which is to ticket you for whatever it was that you were doing, and that's all I intend to do. And then the guy pulls off his hoodie and says, yeah, okay, now you can see me face to face. Will that help? And so they sort of have this conversation. And when I told Robyn I wanted to play this video, she got back to us and said, well, you're going to have to explain the context of why we're bringing law enforcement into it. And it wasn't, we're all familiar with all the issues between minority communities and law enforcement and how that's played out over the last few years. And it's not to bring that situation in here. but it's to tell you that I saw this video and I identified with that police officer. That's who I was sitting at that NACM conference in Portland listening to those judges talk. I was hearing them and I wanted to explain to them, yeah, that is really important what you're saying, but that's not my problem. What you're talking about is really important, but I got this covered. I'm really good at this stuff. So after their presentation, Jennifer turned to me and said, so, what do you think? Is this a big issue for us? And I looked at her and said, no, I don't think so. I think we're pretty good in this area. What do you think? And she said, yeah, I don't remember any incident, anything which would indicate that we're not. I agree, it was good for us to hear, but I don't think that this is a big issue for us. And so we just sort of paused. We've now spent an hour and a half listening to these three tell us their story and what they wanted to tell us, and we've just basically said, yeah, interesting, but doesn't apply to us. And it somehow didn't feel right. So we just had this moment of silence, and then I said, maybe that's the problem. Maybe the problem is we don't think we have a problem, and we don't know, because we're not the ones to be best in position to assess that. So, let's go on. Anybody wants to stay afterwards for movie night, we can watch the clip. But I want to move on because I want to tell you what we did in response. And then if we have time at the end, that's great. So I said, okay, let's do something about it. Let's not just leave this here on the table where we're saying, oh my gosh. Here's what I think we should do. I think we should do an observation. And we should have folks come in and tell us what they see in what we're doing, because we are the worst ones to make that assessment. And so Jennifer said, oh, maybe we can figure out how to do this. And so I said, okay, there are some criteria here. First of all, it has to be totally neutral and objective in the sense that I don't want any of the parties involved to know what's going on. I don't want us to put on a charade for people who are there to observe us, because that doesn't accomplish anything. So I want us to be able to figure out something that happens where we don't know what's happening. That was the number one driver, and the number two driver was, and that's where Jennifer came up with the idea of secret shopper. So the secret's out now. That's what enticed you here is you were wondering, what are they talking about secret shopper? Well, that's it, that it was secret. None of us knew about it except Jennifer. She was the only one. Number two was we were going to have this neutral observation. Actually, there are three parts. They were going to prepare a report and give the report to us, and we were going to release that report publicly without any redaction. So that was our commitment. Here's what we're going to do. We're going to totally expose ourselves to people we don't know, come in and ask them to evaluate what we're doing and how we're doing it, and the impact we're having on the various members of our community. We're going to ask them to then give us a report, and we promise to release that report without redaction. So that's the process we came up with. And the key here in my mind, if you have any interest in following through on this, and honestly, I am an apostle for this. I will proselytize everywhere for taking this step, is don't wait. Don't wait until you have a white police officer shoot a black kid, or you have some issue that happens in court, and you have to try to reestablish the credibility of your court with your community. Do it before that even becomes an issue. Get out there and do it now, because that will even enhance the credibility you're going to have if you follow through on this. Because people are going to say they are so aware of this issue that they're not going to wait for an incident to occur to inspire them. They're actually going to do it themselves. So that would be really crucial in my mind. All right, so let me give you a little context about our court so you can understand where we are and our size and how it might work. We're a 4-judge court. We have 3 white male judges and 1 white female judge. We hear 29,000 hearings a year, basically. We're a progressive community, generally speaking. We live in the Northwest, for Pete's sakes. And we're the state capital, so we are generally aware. We have 3 colleges in town. It's a town of roughly 280,000 people. Of those 280,000 people, poverty rate's 10%, relatively low. 75% of those 280,000 people are white. 8% are Hispanic, 6% Asian, 3% African American. 11% of that 280,000 are non-English speakers as their native language. 90% of the 280,000 are U.S. citizens. So, pretty vanilla, pretty bland group. I mean, that's why Jennifer and I sat there and said, we don't have a problem. This doesn't apply to us. And we just were reflecting what our experience was and the community that we represent and the community that appears in front of us on a regular basis. So I would challenge anybody, no matter what your community is, think about doing this, because we all need this assessment. And we learned great things from the report that they gave us, and a lot of them not even related to what you would believe the obvious issues were. So we came up with this idea, and I said, Jennifer, schedule it. Don't tell me, don't tell anybody else when it's going to be. And that was the deal. So number 1 challenge, I now have to tell my colleagues that this is going to happen. So, have our first judges meeting after Jennifer and I concoct this plan. And, I say, okay, here's what's going to happen. We're inviting people in to come evaluate us, and you're not going to know. You're not going to know who they are. You're not going to know when they're going to be here. And the 3 other judges will look at me like, seriously? Really? And so I don't want to use names, so I'll just use the name Sam. Actually, that's his actual name. He's one of our judges, and he just said, this is going to be the death of independent Sam, because he likes to just sort of spout off. And our former court administrator is in the audience, and she can tell you all about him. But, he's like a judge with ADD. He just says whatever comes to his mind. And he's now thinking, I can't do that. I can't be who I am. I have to, be more circumspect and more measured in all the things I'm doing and saying. And oh my gosh, it's going to ruin my tenure as a judge. And so that was one big challenge. Another challenge was, what do we do with this report? And before we get to what do we do with it, what's the report going to say? Are we going to have names in the report? Or is it just going to be sort of generic? And, we went round and round on that one, and I was of the opinion that if one of us is messing up, we're a state that elects judges. Voters have the right to know that we're messing up, and you have these folks coming. My colleagues didn't share that view. And I will say that there was absolutely no pressure from Robyn and her colleagues in that regard either. And actually, I think they're the ones who sort of talked us out of contemplating putting names in there, rather than just have it, the judges this, or the attorneys this, or the staff that. And frankly, looking back on it now, I would say that was sufficient. And let me take a stop for a minute. If you have any questions, just raise your hand. I'm fine on being interrupted as we go through this, because it will be more pertinent to the point that we're raising. So then you have to think about, okay, we get this report. What are we going to do with it? Are we going to respond to it? Are we going to have a rebuttal? Are we going to ask them to take out things that we find, in our belief, are inaccurate? And like I said at the beginning, we had committed, me on behalf of the rest of them, they had no say in the commitment, was that we were going to do this up front and without any redaction. So I tell the judges, and they finally are on board, and they're saying, okay, we'll go along with it. And then the next thing I do is I call Callie. I call the Chief Justice of the Supreme Court, and I call the head of a local organization called the Black Alliance. I say, we're going to do this. And I'll tell them what I've just told you. I don't know when it's going to happen, but I promise you that we will get a report. When we get a report, we're going to post it on our website. We're going to send it out in a press release, and we'll send you a personal copy of that report so you have it. So we're not going to hide anything, and we're not going to act like it didn't happen if it comes back bad and hope that nobody remembers we said we were going to do this. We're going to publicize it because I think it's important for the community to know, one, that we did it, and two, that here's what it said, and this is what these observers who came in, 2 from New York, 1 from Reno, and what they had to say about what our community looks like within the context of the criminal justice system and the civil justice system. So that, I think, was really important, and that held our feet to the fire. And once we started that, once we made that commitment that we were going to do it, of course, we were bound by it. And that actually was somewhat freeing because at that point we just stopped worrying. It's like, okay, whatever's going to happen is going to happen. We'll just be who we are. And so, Sam couldn't measure himself for whatever period of time it was going to take, because ultimately when they did come out, he was Sam, because he had no idea they were there. Now, there are other parties, attorneys are in the courtroom, staff are in the courtroom, so we did let their offices know that we were going to do this. It wasn't by way of, and do you want to veto it? It was just, heads up, we're doing it, there will be observers here, and maybe they'll make comments about how the public defenders are doing, or the prosecutors, or the civil attorneys. So just know that we're doing it. And there was no significant concern raised by any of those groups. Everybody was okay, a little bit nervous, but okay. And they realized that, one, the purpose was good, and two, they thought, well, most of the ire is going to be pointed at the judges anyway, so their level of concern wasn't as high as my colleagues. So Jennifer scheduled this in April, and Robyn and her crew came out in August. And between April and August, I would come into work in the morning every now and then and remember that we had this going on, and I would say to Jennifer, has it happened yet? And she'd say, no, it hasn't happened. So I'd go into court and promptly forget about it. And so, I asked her 3 or 4 times, and, every now and then one of the other judges would ask me, has it happened? I said, I don't think so. So, one day in August, I was running my mental health court session and went through the whole calendar at mental health court, and there are these 3 women sitting in the back, and everybody else is left, and they're sitting there. And I said, may I help you? Are you students? And I'm not sure who the great prevaricator is, but it may have been Robyn, or it may have been one of her colleagues, said, yeah, we're students. And somebody had tipped them off, and they said, yeah, we go to Evergreen State College, which was one of our colleges. I said, oh, and what are you studying? Oh, a master's in public administration. Perfect. I'm really interested in getting some sort of longitudinal study of our therapeutic treatment courts. I would like to know all kinds of things about age and gender and race and all these things about the people who are being referred and the people who get admitted and the success in the program. Are you guys interested in, as part of your education, maybe doing a study? And these three are, you've got to be kidding me, the guy's falling for this 100%. And so, you know, they make some comments and assure me that, yeah, they'll do a study. So the next morning, I come walking into our weekly judges meeting, and the three of them are sitting there. So it becomes patently obvious, even to me, who they are. So the answer when I said, Jennifer, these are them? She said, yes. Okay, so Robyn and her crew came out and spent 3 days with us. They were in and out of the court sessions. I don't remember them except for that last session. I can't say that I remember their face in any one of the court sessions I had. My colleagues, the same. They dealt with our staff. They went up to the window and inquired about fines they may have owed. They tried to take out a protection order to see how helpful the staff would be with them. They really engaged in the whole process that we had going on in court. And I didn't know that they had done all that. All I knew when I saw them was, yeah, I remembered them from the evening before, and they must have been in some other court sessions because they talked a little bit about it. So they sort of debriefed that day, and then they flew back to New York and Reno, and then we got a report. That was in August. I think we got a report in October, and read the report, and the report started off, well, you live in a pretty vanilla, bland community. So it's not like there's anything outrageous we can point at. And so there was a relief in the sense that none of us are really going to be called out. But on the other hand, it's like, but that's not the end of it. There are all kinds of things that you guys can pay attention to. And so Robyn had her thing on signs up there. Signage is, she said, the signage around here in our dilapidated courthouse is horrible, and people have no clue where to go, and the signs are all in English, and what happens with your Spanish speakers, and all those sorts of things. So those are things we're actually working on, and the signs mostly aren't up yet, but they've been ordered months ago. We're waiting for central services to get them done, but they are coming. And another thing was this issue was really important that they raised about the helpfulness of staff. That last point, number 5, how helpful can you be? Where you can't go over the line of we can't legally assist you, but we can be helpful. And I don't want to put it all on Robyn, the three of them really pushed us to go closer to the line on that in an effort to be more helpful to the public who are coming to our facility. And we shared that with staff, and they are doing a much better job in that. And the judges are doing a better job when you have somebody appearing in front of you without representation. And oh, by the way, every single morning it's good afternoon in the afternoon, and trying to call everybody by their name and try to make eye contact with each and every person called up, and not just look at the 2 computer monitors that we have on the bench. We constantly are talking about that, reminding ourselves of that. And these are all things that they pointed out in the report, things we need to pay attention to. They weren't earth-shattering things. It's not like, oh yeah, we're treating the black community really poorly, or the Vietnamese community really poorly, or anything like that. But on the other hand, given the numbers, you might not be totally surprised by that. But it was really helpful to us to get that report. And I think it was really helpful to the credibility we have in the community when we released that report. We sent it to everybody, and the response basically was a big yawn because there wasn't anything really salacious in there to like, oh, look at this court, it's really bad, or anything like that. But I feel so strongly that we did this, and that I encourage everyone to do it. I spoke at the Washington State Judicial College a couple weeks ago, and I had a room full of new judges, and I talked to them about this, and it met with deafening silence. And you know, my preamble was, I get it, you guys are new judges and you're worried about when you go back to court, you know, what's going to happen that day and the next day, and you can't think of the big strategic issues that you want to start thinking about. I recognize that that's hard to do, and you know, my self-assessment is that in being on the bench for 26 years, that it took me 23 years to understand that I needed to think bigger, to start looking at how my court interacts with the community, how the community interacts with my court, and maybe I should take a bigger view of things. And we have a whole bunch of other projects we've engaged in since then, which I'd be happy to tell you about that aren't related to this. But I challenged them, and there was no takers. There were a couple of the faculty members that were there, colleagues of mine who I've known them for a long time, came up and said, "Oh my gosh, that's awesome. We need to do that." So I would encourage everyone to contemplate doing this. As I said, don't wait until you have an issue. And, you know, one of the benefits that I've seen from this is that, particularly nowadays, you know, when people are looking at their government saying, well, you know, you have the executive, you have Congress can't get anything done. Well, we have the judicial branch, and the judicial branch is a branch of government that right now has the opportunity to get the public to view it favorably. And this is one way you can do that, by saying to the community, we understand that we may not understand you, and we're going to try to be aware of it. We are going to try to be aware of those things that we are not aware of, and the way we can be aware of it is ask somebody to come in and educate us about it. So it didn't just end with the report. We actually had Robyn and her team come back out about 8 months later and do a training for us. And we invited judges in from other courts. We had lawyers invited, staff invited. And when they came in and did a half-day training for us, or maybe an all-day, I can't remember. But it was really excellent. And I felt really glad that we didn't just leave the report there. We didn't say, okay, good report, nothing, you know, overly outrageous in it, and just put it up on the shelf and move on. You know, we addressed it 6 or 8 months later, and you know, we continue to talk about it. We have a motto for our court, and it's called and the motto is serving justice through serving people. And I think that this idea fits really well with that motto. And so we keep bringing it up in conversations with the staff and conversations among the judges, and saying, this is something really important to us, and so I'm on the road trying to make it something that you believe is really important for you. So, Kelly, you want to give any details on?
We've got about 1 minute, and we are going to
Typical
wrap up on
judge.
time. But no, you
Takes
were
all the time.
wonderful, and you're the one that needed to say it. I do want to make just a couple of points that Jennifer had, because I know NACM folks love practical tips, and you want to know, okay, kind of what are some things we can do when applying this. One thing she pointed out that I think is particularly important to know in addition to what you've learned today is, she said it is not expensive. You know, we all have budgets, and we've got to know. The cost of this for them was totally covered by a grant that they got, except for the hotel expenses for their secret shoppers. So that I thought was a good point. Search for grants. Almost every state has a Supreme Court commission, or you have somebody in your state that an Access to Justice Commission. In Washington, it's a Minority and Justice Commission, but partner with someone to try to get a grant to see if they can help you do this. If you've got a small court, it's not that big an issue. Include everybody in it. You don't want to just single one judge and staff out. If you've got a really big court, you may need to select one department or one, you know, the criminal side only or the civil or something, just to get started with it. On your NACM website if you will go, there are going to be the slides from this presentation. Jennifer was really good about downloading all the recommendations. She also asked that I mention to you they did not follow every recommendation exactly. Some are short-term, some are long-term. They're tackling some of the short-term, like the signage. You could find the coffee stand a lot easier than you could find the courthouse. In this, so they're addressing those first, but some things like interpreter scheduling and some others, or more need for facilities, those are things they're tackling long-term. She also mentioned you may want to do a pre and post, a pre-survey to kind of have a baseline, so when you get this post-survey or site report back, you have something to compare it to. Last thing I will mention to you is, again, look at these PowerPoints. All of that information is in there. I have Jennifer's email address and phone number. She is very, very personable, will work with you great, and she invites you to chat with her. So if you want that, come up to me. I'll be happy to give it to you, or Judge Buckley will, I'm sure, too, and she'll be happy to help you get started doing it. I just want to remind you again, you have an evaluation of the session online. Please go to the NACM app and evaluate this, and talk to Robyn and Judge Buckley. They are here for a little while. They are great resources. This was a fabulous idea, and it's working well, and I'm hoping more courts in Washington and across the country will take this up. Paul?
And one other thing that I wanted to mention, in addition to some of the practical tips that Callie had mentioned, that each year NACM produces a guide. And 2 years ago, we produced a guide on creating a friendly court user environment. So it has some great tips on several of the things that the judge and Robyn were talking about signage and some of the problems. And the 2019 guide is entitled Plain Language. So looking at the process, looking at our court forms, our website, and using plain language. So those resources are available. They're in our bookstore, and you can go online to the nacmnet.org website and get those for your use. So thank you again, and thank you to our presenters.
Thank you.
Hopefully you'll all join us for our SIGs. I didn't mean to step on it first.
I was just going to say, there is a workshop on signage on Wednesday at 9:45 if you are interested in more of that. And the plain language guide that Paul mentioned, we've got a workshop already scheduled at the annual conference in Las Vegas, which will be sunny, warm, have no chance of snow, and we want to see all of you there. So if you want more information about that plain language guide, there will be a great session on it there.